A jury in Detroit needed about an hour. What they were reading was a spiral notebook somebody had found under a couch cushion, and they decided it counted as Aretha Franklin's will. That hour arrived at the end of 5 years of court and 4 sons who had stopped speaking to each other. She had a plan. She just never told anybody what it was or where she put it, which happens to be the one instruction every estate attorney gives, and the one roughly 9 out of 10 Americans have no intention of following. 56% of American adults have nothing in place. No will, no trust, nobody named to speak for them in a hospital room or sign on a bank account. Will ownership actually fell from 31% to 26% in a single year. So whatever is happening, it is not progress. Meanwhile, 73% say estate planning matters to them personally. 3 out of 4 agree it matters, and barely 1 in 4 has done anything about it. Nobody in that gap is confused about what a will is. They just do not want to sit down and think about it, which I understand because I put mine off for 2 years. The advice they skip is not make a will. Picture the meeting. The attorney slides the folder across the desk, and then she says the part that never makes it into the brochure, which is to go home and tell your family what you decided, where the paper lives, who is in charge, and why you chose the way you did. 14% of American adults have had that conversation in any real detail. 36% have never brought it up at all. The deeper you get into the survey data, the odder it looks. 97% of families call these conversations crucial, and nearly half have never had one. 68% of parents have not told their children what they stand to inherit, and more than half have never discussed what they are actually worth. More than a quarter of Americans say they have never talked about their end-of-life wishes and do not plan to, not before the surgery, not ever. Anybody who sits with families after a death will tell you the same thing, and they all tell it a little wearily. Everyone agrees it matters, and almost nobody does it, because talking about a will means talking about getting old and getting sick and dying, and we are built to shove all of that away. So families wait for the emergency, and the conversation ends up happening in a hospital corridor at 3 in the morning, with everyone frightened and nobody thinking clearly. It is the worst available room for a permanent decision. It is also the room most American families end up in by default. The cost of the silence turns out to be measurable, which surprised me. 42% of Americans say they would not know what to do if a family member died today. Among people with no documents at all, it is 56%. Among people who have a will, it drops to 19%. The paper by itself does not account for that, though, because a document only tells a court what you wanted. A conversation tells your brother whether he is the one who calls the funeral home. Prince died in 2016 with nothing written down. 6 years of proceedings on an estate valued at $156 million, and the charities he had supported while he was alive received nothing. Aretha Franklin left 3 handwritten wills that contradicted each other. One in a locked cabinet, one under the couch, and the result was 5 years of litigation and a jury squinting at spiral notebook handwriting. Your family will not get a headline out of any of this. They will get a hallway and a docket number. Probate usually runs 9 to 18 months, and contested cases run for years. It consumes somewhere between 3 and 8% of the gross value of the estate before anyone inherits a dollar. So on a $500,000 estate, that is $15,000 to $40,000 gone. In California, statutory attorney fees on a $1 million estate come to $23,000 on their own, before you add the executor's compensation, the appraisals, the publication costs, and the bond. The money is the smaller loss, though, and I think people get that backwards. Without a will, a judge who never met your family decides who raises your children. Relatives can file competing petitions, and that can drag on for months, while a kid waits to learn where they live now. Under most state statutes, stepchildren inherit nothing, and unmarried partners inherit nothing, regardless of how many years you shared a home or whose name is on the mortgage. There is already a default plan sitting there for you. Some legislature wrote it decades ago with no idea who you are. There is a quieter failure almost nobody warns you about, and that is the trust that got signed and never funded. People walk out of the office holding a handsome binder, set it on a shelf, and never retitle the house or move the accounts over. Litigators run into it constantly, a trust that legally exists but owns nothing, while every asset it was built to protect marches straight into probate anyway. Signing is the easy half, and the tedious half is the half that does the work. Reasonable professionals do disagree about the tools here. Some will tell you a well-drafted will, a medical directive, and a financial power of attorney are plenty for a modest estate, and they have a fair point, since only a will can name a guardian for your minor children. Others will tell you that nothing short of a funded trust keeps your family out of court and off the public record. That is a genuine argument about instruments, and I am not going to settle it in a video. What is worth noticing is that neither camp disagrees about the instruction. Every one of them will tell you a plan fails when nobody knows it exists. A newer argument showed up quickly. In 1 year, the share of Americans who trust artificial intelligence more than a human attorney for estate planning went from 20% to 30%, and among the youngest adults, it is 46%. Look a little closer at the same data, though, and it is not the story people assume. Only 5% would use a machine with no attorney review at all. People are not trying to replace the professional. They want a door that is easier to walk through, and that is a reasonable thing to want. It is worth understanding because execution rules are set state by state, and that is precisely where cheap documents fall apart. A will that is invalid where you live has not saved you anything. So what to actually do? And almost none of it is expensive. If you signed a trust, fund it. Retitle the house, move the accounts, check the beneficiary designations, because a trust with nothing in it cannot protect anyone. Name an executor and spell out their powers so they are not going back to a judge for permission to sell a house or keep a business running. Then go back and read the thing occasionally. 23% of people who have a will have never revisited it once, and 15% go 5 years or longer between updates. A marriage, a divorce, a new child, a move across state lines, the death of the person you named, any one of those can quietly break a document that looks perfectly fine sitting in the drawer every 3 to 5 years, and after anything major, and then have the conversation 9 out of 10 people are planning to skip. You do not owe anyone a line-by-line accounting of your net worth. You owe them enough clarity to carry out your wishes without guessing, which mostly means who the executor is, who has medical authority, who has financial authority, where the documents physically are, and what you want done with the house and roughly why. It goes better in pieces than in one summit meeting. 2. Healthcare this month. The will in a couple of months. The house whenever it comes up. Short conversations that repeat land far better than one dramatic announcement at Thanksgiving. One more piece that almost everyone forgets. 48% of Americans have left no instructions whatsoever for their digital accounts, their photo archives, their password vaults, their financial logins. Even among people who hold a will, nearly a quarter have nothing in place. 20 years of family photographs can sit behind a login that dies with you, and no court order is going to pry it open. Roughly $105 trillion is going to move from one American generation to the next over the coming decades, and most of it will move through families that never once said any of this out loud. When people are asked what they most want to leave behind, 41% do not say money or property. They say memories and relationships. That is an odd result to sit with, given that the paperwork all goes to the assets and the relationships get sorted out later by strangers in a courthouse. The notebook under the cushion was never really the tragedy. She wrote it down and she meant it. What cost her family 5 years and cost her sons each other was that nobody living knew it was there. So whatever else you do, make sure somebody knows. Say it out loud while you still can, because silence does not prevent the fight. It just schedules it for a day when you are not there to stop it. If this was useful, subscribe to the channel and hit like. There's more coming.